Hi, I'm Siu Ling Hui, Principal of In Context Finance. Are your business processes fully compliant with the Personal Property Securities Act or PPSA? If not, you potentially run the risk of losing priority over your business assets to other parties who are compliant. The 31st of January 2014 is the end of the transitional period of the Personal Property Securities Act. You must ensure that your business has properly registered all of its interests by that date. Otherwise, you're at risk of losing your assets to other parties. The landmark decision by the Supreme Court of New South Wales in the Re Maiden case in 2013 highlights the adverse consequences of not being properly registered. Before we go on, I need to make it very clear that I am not a lawyer. Nothing in this video constitutes legal advice in any way, shape, or form. You must seek your own legal advice about what your business needs to do under the provisions of the PPSA so as to ensure that your rights are protected. This video is simply to provide an overview of the Re Maiden case and its potential implications for businesses. Let's start with a look at the background of the Re Maiden business situation. In 2010, a company called Queensland Excavation Services Proprietary Limited, which we'll call QES, purchased 3 industrial vehicles: a 30-ton excavator, a 20-ton excavator, and a wheel loader. It financed the purchase of the 30-ton excavator with a finance company and the other 2 vehicles with a bank. QES then leased these excavators to Maiden Civil P&E Proprietary Limited for doing construction work in the Northern Territory. Maiden branded all the equipment with its own name. The PPSA wasn't in place in 2010, but under Northern Territory law, QES was supposed to register its security interest in the vehicles on the Register of Motor Vehicles when it entered into the transaction with Maiden. However, it didn't do this. The PPSA came into effect on the 30th of January 2012. Businesses had to register their security interest on the PPSR to ensure that they retained priority in any claims against their assets. The PPSA allowed for a 2-year transitional phase. If your business had already registered its interest on a pre-PPSA register that was to be migrated to the PPSR, then your security interest would be deemed to be properly perfected for PPSA purposes during this transitional phase. Now, QES hadn't registered on the Register of Motor Vehicles. It didn't register its interest in the vehicles on the Personal Property Securities Register when the PPSA came into effect. Roll forward to May 2012. By this stage, the 30-ton vehicle had been paid off. Maiden now owned this vehicle, but the other 2 vehicles were still being leased from QES, and QES still owed its bank money on these 2 vehicles. Maiden took out a financing facility from Fast Financial Solutions Proprietary Limited. The security provided by Maiden to Fast included these 3 vehicles. Under the terms of the written security agreement, Maiden also gave Fast a security interest over all of its current and future property. Fast perfected its security by registering its interest in the 3 vehicles on the PPSR. In July 2012, Fast appointed receivers and managers to Maiden because of a number of events of default that had happened under the financing agreement. Maiden went into voluntary administration and ultimately into liquidation. QES terminated its lease of the 2 vehicles to Maiden and leased them to another client. The receivers sought possession of these same 2 vehicles from QES as they were security for the Fast facility to Maiden. So who has priority claim over these vehicles? QES is the owner of the 2 vehicles. It also has a security interest in the vehicles because it is a lessor under provisions of the PPSA. Fast has a security interest in the 2 vehicles because they are assets that were included under its security agreement with Maiden. The Supreme Court of New South Wales said that this case was not about resolving the claims of ownership versus the claims of a secured party. It was about resolving the competing priority claims between 2 secured parties. The fact that QES is the owner of the vehicles isn't relevant in determining who gets priority. It is QES security interest in the 2 vehicles that is being weighed against Fast security interest in the same vehicles. QES never registered its security interest in the vehicles on the Register of Motor Vehicles when it entered into the lease transaction with Maiden. So when the PPSA came into being, its security interests weren't protected under the PPSA transitional rules. And it didn't do anything about registering its interest on the PPSR either when the PPSA came into effect. However, FAST had properly registered its security interest when it took security over the vehicles. It had perfected its security interest in accordance with the PPSA. Therefore, FAST security interest in the vehicles was given priority over the interests of QES. There's another huge business risk of not being PPSA compliant. Now, under the PPSA, an unperfected security will vest in the grantor of the security once the grantor has an insolvency event. Maiden is the grantor in this case. So when Maiden went into voluntary administration, the QES security interest in the vehicles became vested in Maiden. In other words, QES basically lost its security interest in the vehicles. As a result, FAST held the only security interest in the vehicles. QES was reduced to just being an unsecured creditor. The court ordered QES to give FAST possession of the vehicles. QES problems didn't end there. It still owed money to the bank for those two vehicles which it had just lost, and those vehicles were the security for that loan. But the bank didn't lose out because it had recourse to the personal guarantee of one of the directors of QES as well as a mortgage. The Maiden case highlights the importance of registration of your business assets in accordance with the provisions of the PPSA. Otherwise, your business is at risk of losing its assets to other parties. The business situation in the Maiden case was about a leasing transaction, but the PPSA is not limited to leasing transactions. In fact, virtually all transactions except those that relate to land and buildings are caught under the PPSA. For example, if your business sells goods on credit terms with retention of title, or your business sells goods on a consignment basis, or you store goods at third-party locations, you run the risk of losing your claim on those assets unless you have properly registered your interest in those goods in accordance with the PPSA. Make sure you are prepared for the end of the PPSA transitional period. Are your business processes compliant with the provisions of the PPSA? Have you been relying on transitional provisions to protect your security interests? Speak to your lawyers or other specialist PPSA professionals to find out what you need to do before the transitional provisions end at midnight on the 31st of January 2014. That date is critical. Getting properly registered by that date can make a huge difference in your risk exposure. If you register before the end of the transitional period, the priority date will be backdated to immediately before the start of the PPSA. If you register after the 31st of January 2014, then the priority date will be the actual date of the registration. Someone else could have registered their security interest against one of your clients during the transition phase, and you stand to lose out on priority because of the timing of your registration. Thanks for watching. If this has been useful, please like and subscribe to my channel.